Good evening. We'll call the meeting to order tonight. Would you, Commissioner Garrity, like to lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Can we have a roll call vote?
You may. Commissioner Maggio, Commissioner Gregoire,
Here.
Commissioner Topchian,
Here.
Commissioner Charity,
Here.
Commissioner Buckles, Vice Chair Bergstein, Chair Kerpies.
Present. All right, has everyone had a chance to review the agenda?
Motion to approve?
Second.
All right. All those in favor say aye.
Aye.
Any opposed? Motion carries. And what about the minutes? Everyone had a chance to review the minutes for March 8th?
I move approval of the minutes.
A second.
Second. All right. All those in favor say aye.
Aye.
Any opposed? We have minutes approved. And we will start with public comments. I believe many of you have submitted public comments, but if you're not here to speak about the item 10, cost-sharing options for mandatory seismic retrofitting and further analysis, and you'd like to speak at the very beginning of the meeting, can you raise your hand just so I know, make sure we've got you in the right category? All right, so you're all here. Oh, you'd like to speak for the public comment in the very beginning?
He's the appellant.
Oh, okay. We'll get to you in just a moment. You get to speak. I just wanted to make sure the speaker slips that I have up here are not out of order, and so that we're going to skip over this public comment in the beginning, and we'll move right into Director's Manager Report.
Hi, good evening, Commissioners. We will be hearing an appeal tonight, and obviously the cost sharing for seismic retrofitting and exploration of a pass-through. At the April 26th meeting, there'll be 2 appeals and a continuance of the cost sharing for seismic retrofitting. Also be aware that there'll be a closed session item on that day, so you'll need to be available as of 6:30 p.m. on April 26th to listen in on that closed session item. For our May 10th meeting, there will be 2 appeals and hopefully a report on the subcommittee on proactive code enforcement. May 24th, our continued look at the cost sharing for seismic retrofitting. The June 14th meeting will have 2 appeals. Looks like we'll be really busy in the few months regarding these appeals. And the June 28th, more discussion on the cost sharing for seismic. And on July 26th is our annual study session. Thank you.
Thank you. Do we have any questions for staff? Seeing none, we'll move into Commissioner comments.
Nothing for me.
All right.
Nothing at this time.
Nothing? Okay. So no comments. We will move right into the appeal then. This evening we have an appeal D-4274, 1205 North Formosa Avenue, number 5, rent reduction appeal. Do we have both the appellant and the property owner available? You're the property owner? Okay. You're the appellant. Sorry, we can't hear very well up here. Yes, in just one moment. We're going to receive a staff report first. Do we have the property owner? No? Okay. We'll move right into the staff report, and then we'll hear from you.
Thank you. Tenant Eddie Pashtian has lived in Unit 9 at 1205 North Formosa since June 1997, currently pays $780 a month. The hearing examiner awarded a rent decrease of $70 for the removal of a parking space. Mr. Pashtian has appealed and claims that the amount of the decrease is lower than that provided by the guidelines. Moreover, he claims that the landlord can charge a new tenant much more for this space, and therefore there's no incentive for the landlord to restore the parking space. Staff recommends that the Commission affirm the hearing examiner's decision. The valuation was based on the fact that the city determined Mr. Pashtian's space is not a legal parking space. The city cited the owner for allowing tenants to park in that area. Thus, the hearing examiner reasoned that while the housing service has been eliminated, its value is reduced by the fact that it was not a legal space. Because this conclusion is reasonably supported by the record evidence, staff recommends that the decision be upheld. In addition, because it is an illegal space, the landlord will not be able to rent it out to a new tenant. And the record shows that there are now no parking signs in that area where the space used to be. Thank you.
Thank you. Do we have any questions for staff?
Yeah, hi, good evening, Ms. Allison. I have maybe one or two questions. The examiner used the suggested guidelines, or there was the amount that the examiner determined outside of the suggested guidelines? Because the guidelines, they give 77 to 145, I believe, for the parking, the
Right.
ranges.
So it depends on the type of parking space, right? So I think she kind of, it seems to me based on the amount that she started perhaps from the lower end because it's an uncovered, unsecured outdoor parking space, and then reduced it from there.
So what if they, let's say that if the service was a legal, if the parking space was a legal parking space, can we presume that the amount of the reduction could have been higher than $70?
Right, that seems to be the hearing examiner's reasoning, that she reduced the value because of the illegality of the space.
Okay. Because I read the decision and the facts, and I saw the reference to the unsecured and uncovered, but I didn't see where the examiner was reasoning the findings based on whether this parking space was legal or not. Maybe I missed that part somewhere.
So at the end of her decision, she talks about the citation that was issued, and the citation was based on the fact that it's not a legal space.
On page 22 of the hearing examiners, or 22 of our packet, of page 6 of her decision, the very last full sentence also references it. I'm sorry, the second to last, I guess.
I'm
So-
reading uncovered, unsecured space. Well, maybe where are you referring to specifically?
So on page 22, or on page 22?
I'm looking at
Okay.
22.
So in the third paragraph down, that large paragraph, the very last line after the footnote of 21, where it begins the full amount.
So
of
parking
this-
space is not a legal parking space, this part. All right. Okay. Nothing further this time. Thank you.
Any other questions for staff at this time? All right. Mr. Pashtian? Okay, if you could come forward, and you will have 5 minutes to provide comments in support of your side. Do we have the tenant present? I'm sorry, you're not the tenant. You are the tenant, I know. Do we have the property owner in? No? Okay. Just wanted to make sure. 'Cause, you'll have 5 minutes. Normally, we'd allow you to break it up, but since you'll be the only one speaking, you'll get your whole 5 minutes, and you can use up to that amount.
Okay, great. So I thought about what I'm going to say, and for your convenience, I printed, just in case you want to refer to it in the future or today, the exact statement, if I could just give it to you. It's no new evidence.
No, as we mentioned earlier, you cannot at this time present them with written material.
Okay. So I'm just going to read the statement.
Okay?
And I will refer to evidence that was in the first hearing and evidence that was discovered in the first hearing as well. Just 1 second.
Can we stop the time just for a moment while he's
Yes.
technical?
I'm done.
Okay, there we go.
Thank you. So today I'm seeking, first and foremost, a parking space to replace the old space, which was given to me under the pretense that it was a legal parking space. There is one available in our building as we speak, by the way. If this is not possible, I am seeking a reduction in rent equivalent to the value of the monthly parking space area to rent in my area. So I'm going to quote what the hearing examiner wrote. The hearing examiner reasoned, quote, "While the housing service has been eliminated, its value is reduced by the fact that it was not a legal parking space," end quote. So I believe that these should be considered in making a decision. Number one, the fact that the management and the landlord knew it was an illegal parking spot, yet did not disclose this to me. This was brought out in the meeting. In the first hearing, I believe on page 2 of the analysis. So since I cannot give it to you, you can refer to it. It's on page 2 of the analysis. It says, "The evidence in the record shows that the owner allowed Mr. Pashchin to park his car in the area outside the carport and near the laundry room. The manager was aware this was not a legal parking space, but allowed the tenant to park there." Number 2, the management filed with the city of West Hollywood as a legal parking space in the re-registration form. So this evidence was brought up by the hearing examiner herself, and if you would look at the re-registration form, it would indicate that there is a check on the parking space, and in addition, there is a digit of number 1 where it says parking space. So again, it's in the re-registration form which they filed, and I have nothing to do with that. Number 3, they charged me for 20 years, as I'm still paying for it as part of my rent, for the full, not reduced value rate for the parking space, which now we're talking about the reduced value. So they charged me fully. The parking space was included in the rental contract when I moved in June 1997. So that's about 20 years ago. I used the parking every day for 18 years until 2015, when there was a fire in the building and my old parking and apartment 2 parking were taken away. In other words, there was another parking that was taken away that belonged to apartment 2. Since then, I've spoken to Mr. Katz and his wife, Esther Katz, the owners of R&E, requesting any other legal parking space as a replacement. I was verbally promised a space but never received, despite the fact that there were many available in the past 3 years. When I moved in 1997, I agreed to pay fully for illegal parking, and I'm still paying for it. The parking is specified in the rental agreement. However, I misplaced my copy of the agreement and requested numerous times for a copy from the management. As it is my right under the law, no copy was provided to me. The management filed the re-registration form with the city of West Hollywood. In this form, the landlord checked the box indicating the digit 1 for 1 parking space, where it said parking space quantity. The landlord submitted this form and indicated so as a completely legal parking space, thereby misrepresenting it, not only to me, but to the city of West Hollywood. This shows bad faith. However, I'm the one suffering the consequences, especially because I'm a disabled person. The management was renting another space to apartment 2 for as long as I was living there.
That's your time, unfortunately. Does anyone have any questions for?
I guess I had a question. There's no dispute here. The hearing examiner did in fact determine that you suffered a substantial reduction of a housing service. So that issue is really off the table. I guess the question before us was whether the valuation. So the question I had for you is, did you present any evidence at the time of the hearing to support an alternative valuation to what the hearing examiner determined? Did you present evidence of what other parking spaces would rent for or anything?
You mean the evaluating how much a space is worth?
Right.
Well, as somebody brought it up earlier, I believe that Mr. Agassi, in the guidelines, it says 77 and up to 150. Well, she decided to go below the guidelines. So I did not submit anything as far as the value. But I did search for the value now, and it seems to be triple, quadruple if I were to rent a parking spot per month. So this is, I believe, this is completely unreasonable. It's not even close. And again, if I were to search for a parking spot, this wouldn't be much, to do. And I believe because it was none of my fault, if anything, the management submitted to the city an official document saying that there was a parking spot that belonged to me.
I think we're going beyond the question, yeah.
Yeah, you answered my question. Thank you.
Thank
Are
you.
there any other questions?
No,
All right, I have one question for you. Had you reviewed the guidelines for the value of the parking prior to or during the hearing?
Well, I looked on the internet how much,
In preparation,
but
but
I
I'm
did
asking about the
not- but I did-
guidelines that she followed.
but I did not present any figure as far as that. I looked for my own self. I did not present any figure.
Prior to the hearing, you did?
Yes,
Okay, thank you.
sure, thank you.
Okay, we'll move into discussion. Would anyone like to begin? Oh, you can go ahead and have a seat, I'm sorry.
Thank you very
Yeah,
much.
Thank you.
Thank you.
Chair Krupas, I wanted to kind of a clarification first. I don't know whether the question that this, the argument about the parking being illegal or not, that kind of troubles me. And that's been my position for many years when it comes to matter of a reduction of services regarding the legality of the parking space. My concern is, how is that the fact that the parking was illegal is the tenant's fault? And that's been the argument that I always use, but I know that our commission, we have, in the cases before, we always had the similar arguments, and we allowed sometimes nominal rent reductions because the service was illegal or cited by the city. So it always troubled me because I don't see that is reasonable. I don't see how is that the tenant's fault that the service is illegal and the city cites the landlord for something that the landlord benefited by providing and renting maybe collecting a higher rent, and now the tenant is being penalized by being provided a lower rent reduction because the service was illegal. So I don't really see a connection. It bothers me a lot. I'm not disputing at this point the specific amount of the $70 of rent decrease. If I was the examiner, I most likely would have used a different rate, but I don't want to really talk about how much the reasonable amount would have been or fair amount would have been for this particular case, because I would take into consideration also the amount of the rent, etc. But my concern is why we are focusing on the fact that the service was illegal. This is not the tenant's fault, and the examiner should have never really used that argument, in my belief. Maybe something we need to do in the future to kind of change the regulations, but so that's the discussion I want to hear from you, commissioners, and maybe legal counsel may clarify that.
What would you like first, the legal counsel to
Let's-
discuss it
yeah,
first? And
let's
then
put
then
legal counsel
probably
on the spotlight.
better if she speaks first, and then we.
Well, the thinking is, it's not about fault, because I don't think there was an establishment that it was the landlord's fault either. I think there was testimony that this only came up for the first time a couple of years ago. I think the tenant has been parking there for close to 20 years, and so this came up for both of them at the same time, it sounds like, from the record. And so the idea is to try to take an objective view. And so when something is illegal, arguably that lessens its value, as a percentage of the rent. So the example I used earlier was, if I think we even had a case where there was a clothesline that was used for quite a long time, but then the insurance company demanded that the landlord take it down because it was a hazard of some kind. And so in that case, it was definitely a substantial reduction of a housing service, but the danger to the tenants, for example, outweighed whatever value the clothesline had, so it was de minimis. Arguably, you could say the same thing here. You know, there are reasons why the parking space is illegal. Does that pose a danger of some kind to someone parking there? Arguably it does, because people can't maneuver in and out of their spaces safely. So that's the reasoning, to try to keep it objective rather than saying fault on one hand or another, unless there's some evidence of that.
Would anyone else like to speak on that?
I was saying I couldn't have said it better, but I've been on the commission long enough. We've had a bunch of cases that come before us that involved a reduction by the hearing examiner to account for the fact that something was, a governmental authority had ordered that something be removed for purposes of health and safety. I guess I agree with Commissioner Topchin in theory that it's, I do agree that the reduction should be reduced, or the award should be less because it was an illegal spot. And I think what legal counsel said, it's like, well, what's the value of any legal parking space that is outside and uncovered? And look, if I were the hearing examiner, I might have just felt that it should have been a higher number or a lower number. I don't know. I wasn't the hearing examiner, but there definitely is precedent over the years for reducing the size of the award, if some governmental agency has determined that the use of something is illegal. So I would support affirming the hearing examiner's decision because I think the record before us provides us with substantial evidence to support his or her decision.
Mr. Garrity?
So I agree with a few of the previous comments. I think that, here we either have to, we have to admit that we're a municipal body and we are constrained by the laws of West Hollywood as the Rent Stabilization Commission, abiding by the Rent Stabilization Ordinance. And this sucks, candidly. You had a parking space for 20 years and now you don't have it. And that doesn't feel great. However, we, as the Rent Stabilization Commission, don't have it in our ability to make you as whole possibly as you would like to be, but this doesn't have to be your last stop. You do have a contract and you do have landlord-tenant law and there is contract law. So even though, yes, through the Rent Stabilization Ordinance, you can get a reduction in your rent, this doesn't have to be your last stop. You can consult, outside a legal opinion and possibly have another body of the law make you more whole. I just think we are constrained as an appellant, as an appeals adjudicative body by the laws of West Hollywood. And I can't see in the record, especially based on the precedent of a prior case that was before the commission where an uncovered unsecured spot was $71.50 in a prior case where the rent reduction was $71.50, and now we have one that's exactly like that, but it's illegal. So you're missing $1.50 from a prior case. I can see the hearing examiner's reasoning here, and I would be in favor of affirming it.
No, you can't. We have to deliberate right now. Before we go back around, because I think we'll maybe do another round possibly, but my recollection is that we have had this conversation several times about whether the service was removed by as a result of being a code violation. And I think I've always been consistent, and I don't recall whether the commission went the way I wanted them to or not, but I know that I, for one, have always been consistent in my argument that this is not of concern to the tenant. The services provided to the tenant are entered into upon their lease, and that if something is removed from that agreement, then we look at the value of that. And I understand slightly in theory that things that are illegal are less valuable than what they would be on the open market, but there isn't evidence of that. In this record, there isn't either way, that it's more valuable, less valuable, that value is affected at all. We're also not, I couldn't find in the city's rent stabilization ordinance any reference in terms of whether we are bound by having to devalue something or provide a lower value simply because it's illegal. In fact, on page 22 at the end of her decision, she specifically says the full amount of this valuation is not supported as the area where Mr. Passion parked is not legal parking space, a factor that should be considered in valuing the housing service. And that last line, a factor that should be considered in valuing the housing service, is not supported by our rent stabilization ordinance. It may be common practice in the court of law or anything like that, but what we have to follow, or what I feel like I am obliged to follow, is what I know to be the law and what I've always argued in the past. And so I don't see how this is the value is less. I mean, I would say that if the guidelines value parking in a range of $72 to $144, then $72 is what it should be. And I know that's only a $2 difference, but she seems to make all the arguments for why it is at the low end of that, unsecured, uncovered, but I just can't let that go, that it's being devalued simply because it is not up to code. Did you want to go start again, Chopchin? Or Commissioner Chopchin?
Yeah, you partially answered the question. I was going to ask if we could make reference to a specific section in the RSO or regulations that provides that the service could be devalued because of the fact that the service is illegal. And I couldn't. Maybe Alice, Ms. Regan can point out to a
Sure.
specific section.
It's in the regulations. It's section 60041, heading substantive grounds for downward rent adjustment. And letter B says, in evaluating the amount of rent decrease, the hearing examiner or the Rent Stabilization Commission may consider the extent to which the reduction in services affects the safety, health. So health and safety is one of the factors that you can rely on.
Which section was that? I'm sorry.
60041, it's page 53 of the regulations.
I thought I was on the right page.
And that's what the interpretation is, safety and that part of that. I'm familiar with that. I was actually going to point out to the same section, but as I said, if I was the examiner, obviously I wouldn't interpret it that way. That is a concern of the examiner at the time. She heard the case. I disagree with that, but again, she or he heard the case, and there was a decision. But I don't believe that if we go back to the basic philosophy, the tenant rented in 1997, rented the unit, paid the rent, whatever the amount was at the time, and that rent included a parking space. Obviously, that rent amount included a service at the time, and the value, I assume, was higher than a comparable unit with no parking space. Or even if we take a hypothetical with today's rent, a rent with a parking space in West Hollywood would be probably $3,500 for one bedroom, and with no parking space could be $2,500 or $2,700, hypothetically speaking. So there is a huge value given to the fact that there is a parking space, regardless it's legal or illegal. And assuming, again, hypothetical situation, the owner is renting a unit with an illegal parking space and putting a value, $700 basically, incorporated in the rent amount. So that's the philosophy I see as a landlord might use by renting a higher, setting a higher value for that unit by knowing that the unit is, the parking is illegal. So, and when it comes to the point of the rent reduction, why we're, again, penalizing the tenant and using the lower amount for rent increase when it's not the tenant's fault and the landlord benefited all this time by collecting higher rent. So that's the trouble, that's the problem that I have by reviewing this argument. And I'm sorry, I don't know how can I really justify that, but I don't think I can, support this decision.
Before we move on to the next one, can you tell me again where you're finding it in the regulations?
Sure, 60041,
60041.
Yeah, and then right here.
letter B.
Thank you. Okay. All right. Anyone else would you like to go?
You know, I would also point out that the rent is only $780. So the rent reduction actually was a tenth of the total rent. So that's also a factor. I don't think the hearing examiner mentioned that in her decision, but it's also something to keep in mind.
I don't know if, that, to me, that would seem like new evidence that we shouldn't be considering since the hearing examiner didn't.
It is not, in fact, new evidence, and
Oh, yeah,
it is,
yes,
in
you're right.
fact,
It's not
in the
new
record.
evidence. It is the fact that, that I didn't mean it that way. I meant just
Right.
your reason.
I hear what you're saying.
Commissioner Cherry?
Counsel, do we know why the parking spot is illegal in the city of West Hollywood?
So I think the citation is in your packet.
Yeah. Can we review why?
So whatever the citation to the municipal code there, I don't know if it was the dimensions or where it's located. It sounds like from the letter accompanying the citation that it was hindering people exiting. It was creating a safety hazard because it was hindering people from entering and exiting the legal parking spaces.
Yeah, I see the citation. I just didn't see, exactly what was going on there, so that's why I asked.
So in 18 years, nobody ever from the housing department ever entered the property to observe that, or there were no complaints from the tenants filed?
The record shows.
From 1997 to 2015 until it was discovered that
So the record shows there was and I'm looking at only at the record shows there was a fire, and as a result of the fire, the code compliance officer came out to do inspections, and that's when it was discovered.
I see.
And I just, I'm still not persuaded to put much weight in the fact that it was removed by the code, because in this regulation, it talks about safety, health, convenience, and comfort of the tenants. And if anything, if we want to look at the big picture here, the record shows that the tenant disabled, preferred that spot, made it easier for his access in and out of the apartment. So if anything, I don't want to go down that path because I don't think we need to, but I'm just not persuaded, I guess, for the regulation applying here for the no, I'm sorry, you cannot speak. It's just the commission at this point, all right? Thank you.
So, Chair and Commissioner Topchian, are you proposing that we would have a valuation of $72? Is that what you both would be proposing here?
That's what I would be proposing at the minimum, but I haven't heard anyone else say that yet.
Well, I believe the current guidelines, they say the floor is 77.
Oh, I
far
thought it was
as I know.
72.
I think it's
I
72.
checked the website,
Okay.
the city's website, it shows 77. And
I am suggesting the minimum of the current guidelines is what I'm suggesting, whether it be 72 or 77.
How much is what is the current rent?
Well, the commission is certainly entitled to set a new valuation for this, although I would urge us not to in this case. I sort of feel like, I sort of feel like that there is substantial evidence to support the valuation here. So I would urge us not to set a new valuation, but
But what's the current rent?
Well, I just said that 72 was the low range. Like, I'm not, I guess I'm not making the argument that we need to lower the value. I'm making the argument that the hearing examiner shouldn't put as much weight, that she erred in putting that much weight in the fact that it was removed via code. I guess that'd be my argument, even though we keep on talking about numbers. I'm not suggesting that we alter the number other than put it at the minimum of the range, if that makes some sort of sense.
Well, I would be okay with at least using the minimum for indicating this guidelines. So I would agree with that.
Is that a motion, or does anyone else want to speak on?
Yeah, I would probably make a motion to revise the amount of the rent increase to reflect $77.
I don't know if, I think there's a question about if it's 72 or 77. In the record, it shows that it was 72 to,
Let me, if we go on the web.
but I don't know what the actual current guidelines are. Maybe the staff report was wrong, but I guess it's in the record. The staff report says that the guidelines for value and parking range from 72 to 144.
Chair Kirpis, I checked the website. Unfortunately, I have a problem with the connection, but before coming to the meeting, I checked the website and it showed $77.
Could we get an
There we
answer
go,
on
I
that?
can-
You were the author of the staff report, so I'm referring to page 22 on your, or of our packet. I'm sorry, I guess you were not the author of this. This was what the hearing examiner
Have the
wrote.
valuation guidelines gone up since the decision?
I don't know. I can try to pull up the website on my
Yes.
iPad, but to find out what they are.
Would it be okay if we made the motion that it be the minimum of the staff report at the time of this decision?
Yes, if that's what the commission wants to do, then whatever the minimum, the low, what you're saying is the low end of the range.
Of the range.
Of the guidelines.
As of the date of her signature on the decision. Would that be appropriate? Would you accept that? So it would be the minimum of the range.
At the time.
At the
time of her
At
decision.
the time of the decision, yeah.
I'll second that. Do we have more discussion?
What's the motion?
The motion is to set the valuation at the minimum range at the time of the decision, not any updates to the code since then. So to set the minimum valuation of this rent decrease at the time of this decision.
And if we could add that into the, or remove any reference
To
of
the
the fact that it was removed by code out of the final resolution, would you accept that?
I would accept that. Actually, that's the second thing I was going to suggest, that if we remove that language and the reference to the service being illegal, because I don't really believe that that's relevant, to be honest with you. We're just going to use as a reduction of parking services based on all other factors, but not whether the service was cited or not.
So I'll second that. And then is there more discussion? Does that make sense to you what the motion is now?
Yes.
Yeah.
Well,
Someone like to call it a question then if there's no more comment? Or did you have a comment?
Nope.
I'll call it to question then. It's only four of us. Can we get a roll call vote, please?
Commissioner Maggio, Commissioner Gregoire,
No.
Commissioner Topchian,
aye.
Commissioner Charity,
Aye.
Commissioner Buckles,
Abstain.
Vice Chair Bergstein, and Chair Kirpis.
Aye. So the resolution RSC 18517 will, I don't even know if we're affirming in part. We are affirming in part, right? The resolution?
Yeah, so the appeal was just about the valuation, but essentially you're affirming affirming in part and reversing in part.
Okay,
And I'll bring back a resolution conforming to your
great, just
decision.
those two things. Thank you. Thank you, everyone, for being here for that. We will now move on to.
By the way, it is $77 on the website.
Right.
The current.
That's what we said at the time. Yeah.
Okay.
So Chair Kirby's, the landlord has appeared. Obviously, he's late at this point.
Not the gentleman that was, you're not, yeah, I agree. It's hard to see back there, so, okay. So was that him speaking during the time? I kept on thinking it was the gentleman in the back, the tenant.
It was.
Oh, okay.
He was,
Okay.
during your deliberations, he was trying to get your attention, yeah.
Okay, well, I think, can you advise us on, he was late, right?
Yeah, I mean, technically, the appeal, the oral argument portion had concluded, and they had
I asked a couple times. Yeah, I mean, yeah. You can address this during public comments if you fill out one of the forms back there. It's going to be about 15, well, I don't know how many minutes, but it'll be a little bit later, but you can fill out one of the forms. It will be on the record when you go, when you speak in public. But for now, we're going to move on to the next item on the agenda, which is unfinished business, I believe. I always lose my agenda about this time. And I believe we are on the item 10, unfinished business, the cost-sharing options for mandatory seismic retrofitting and further analysis. Tonight, I think we'll receive a staff report, right? But we will be reviewing the timeline for further analysis of the upward rent adjustment application, an exploration of an alternative possible direct pass-through, and a plan to increase community engagement. We're just going to receive and provide some input this evening, the commission will, but we'll start with a staff report.
All right, thank you. As you already know, we did talk about this topic at a previous Stabilization Commission meeting. Those recommendations were presented to City Council on April 2nd, 2018. Council then provided us more, just that we continue analyzing these costs. And if you see there, they're asking to direct staff to continue exploring the appropriateness of a pass-through for landlords to share costs for mandatory seismic retrofitting with tenants with the following provisions: limited to a percentage of project cost, capped at a maximum dollar amount per month, in effect for a set period of time, and include financial hardship exemption for tenants unable to pay. Additionally, they wanted to direct the Rent Stabilization Commission to continue its analysis of the issue, including an analysis of actual cost of retrofitting, whether a pass-through is appropriate, and whether current process for applying for a rent increase is sufficient, and provide a recommendation. So at this point, what we want to do is focus on page 44 of your packet. On the bottom portion of the page, there's several meeting dates that are listed here. We want to make sure that the commission would be available, particularly to the community meetings that are scheduled for May 17th at West Hollywood Park and June 13th at Plummer Park, so that you guys are able to hear out what the landlords and tenants' concerns, will be sharing at these meetings. I just want to make sure that you look at your calendars. If there's any conflicts with other events that may be occurring in your calendar, we'd like to know that at this time.
Do you have the time for those meetings? I don't see them on the page, that's all.
I believe they will be at 7 p.m., but I can get back to you via email with the correct time.
I'd like to point out one thing that's not in the staff report. Council directed, at their last council meeting, council directed staff to inquire with the city of Santa Monica regarding their decision not to allow a pass-through. So I don't know if this accounts for that that inquiry, that research. And so I want to make sure that the commission is aware that that is also an option, not allowing an automatic pass-through.
Not allowing the pass-through, meaning not allowing the setting the cap, the amount, the fixed amount on the,
No, just leaving it status quo, which is
okay,
not approving an automatic one-size-fits-all pass-through,
okay,
but requiring the owners to come forward on a case-by-case basis.
all right, okay, all right.
And it also, that was one thing I do remember, that additional information was asked about, but also there was, and maybe this was just council dialogue, I don't know if it was actually part of the direction, but basically a broadening, an encouragement of broadening to all options, and to, one council member specifically talked about alternatives to financing. Was that part of,
Right, so they're already looking at using the Housing Trust Fund to subsidize some of this, so that could replace this as well.
Okay. So I guess my point is for members of the community, whether you hear it at home or you just hear it through the grapevine, is that we want you to come and tell us your ideas, because there might be two proposals in front of us right now, but we are open to all options
Right.
if they make sense and achieve the goals we want to achieve.
And just as your legal counsel, I also feel like it's incumbent on me to point out to you that Costa-Hawkins, don't keep in mind that Costa-Hawkins allows landlords to set the initial rent at any rates, and one of the purposes of Costa-Hawkins, that's what the landlords were arguing when it was enacted, was to allow these capital improvements. So the fact that some landlords may have done the right thing and implemented these improvements already, and it's only now that it's mandatory, and those landlords who have arguably waited, is it appropriate to give them some sort of a subsidy on, through a cost sharing on the tenants, when arguably Costa-Hawkins should take care of it? And if not, the landlords have an ability to come to the city through a rent adjustment process and argue that they should get an additional rent increase on top of what's already available.
Thank you.
I just wanted to clarify one of my biggest concerns were, at the last meetings we had, I pointed out to the include parking and storage issues as a mediation.
Is this a question?
Is it here?
Okay. If this is just a question, because I just want to make sure that we do our conversation after we hear the.
Right. It's a question to for the manager. Those issues, parking and storage, are included in this report, because I'm trying to find it.
I thought that was habitability report.
Or this.
Or it's all pushed together. I thought the habitability plan was, regardless of what we do with the pass-through, the habitability report is going to be a program that's done just
It
to
should
deal
be
with.
separate from it?
Well,
It's not
to
gonna be-
deal
okay.
with the construction.
All right.
That's
Okay,
correct.
so then, yeah,
That's
it
correct.
answers. Thank you. Nothing further.
If we don't have any other questions, then we'll move to public comment.
Just to clarify, all we're doing is today speaking to the timeline, right? And the community outreach. We're not providing any substantive comments on the proposal tonight, right?
I don't think so.
That is correct.
Yeah,
Okay.
we can accept substantive comments, but we can't, there's no reason for us to suggest them, I don't think, right now. All right, so if there's no other questions, we will go to public comment. We will start with, each public comment will have 3 minutes. Please, when you come up to the podium, state your name for the record, and then you'll have 3 minutes. Please try to stick to the 3 minutes. That way everyone it gets the same amount of time. Matthew Kincaid, followed by Jennifer Kreendler. Sorry if I'm not saying your names correctly.
Okay, I'm a renter.
Could you start with your name first?
My name is Matthew Kincaid. Okay, I am a renter. I do not own the apartment complex where I live. I shouldn't have to pay for quake retrofitting. I literally, I cannot afford to pay for any of this. Some of my neighbors are senior citizens on Social Security. They can't afford to pay for this either. In the complex where I live, many people move in and stay for only 2 to 3 months. Would they have to pay for retrofitting too? This is a slippery slope. If I can be forced to pay for earthquake retrofitting, the landlord might try to get me to pay for other repairs to the complex as well. So I'm opposed to this cost sharing. Thank you.
Thank you. Jennifer Kreenler, followed by Ben McCormick.
Commissioners, I don't have anything formal here, but I've...
You start with your name, I'm sorry.
What's that?
Start with your name.
Oh, yeah, Jennifer Krindler, thank you. I'm one of the neighborhood watch co-captains on my street. I'm on Ogden Drive, and I've lived in LA 15 years, here in the city about 8 years in West Hollywood. Love this city. Love my rent-controlled place, too. And... you know, just as the gentleman's saying, I believe that this should not be a cost that is incurred by the tenant or the renter. If termites were riddling the foundation of the building, that's not an expense that falls to me. If the roof is caving in, that's not an expense that falls to me. If a property owner has purchased a building that ultimately is going to be unsafe in an earthquake, I truly believe that this should fall to the expense of the property owner. As far as cost sharing goes, and coming up with this hardship exemption for lower income tenants or tenants on fixed incomes, you know, I'm a hardworking social worker, and I do live paycheck to paycheck, and even though I make a decent income, I wouldn't fall into a low income category, but I don't fall into a category that would allow for somebody like me to be exempt. And I think there's going to be a lot of us in the community that are going to fall in a gap here that may not be low income, but will not be able to meet qualifications for these exemptions you're calling for, or that are being proposed. And that's going to place a huge hardship on me in general. And as far as trying to increase tenants coming out and speaking and participating in this process, a lot of these mailers and things we get from the city are just kind of thrown in the mix in the mail and look like junk. So I think if you were to try to elicit a lot of the landlord's help with having some sort of flyer to us with clear verbiage like rent increase, something scary that would really provoke us to want to come out, I think would be an effective way for tenants to be more notified of this. So utilizing landlords as communicating this information and not just coming from the city. So thank you.
Thank you. Ben McCormick, followed by Misha Irwin.
Good evening, Chairman, Commissioners. Ben McCormick, 14-year resident of West Hollywood. One of the main reasons that West Hollywood was founded in 1984 was LA's proposed elimination of rent control. It has been a haven for renters ever since. Many of us, myself included, are pleasantly stuck in our current homes due to the fact that we couldn't afford to live here at today's market rates. Many of us chose to be renters, not owners, for the sake of not having to pay for the upkeep of the buildings we do not own. I owned a co-op in New York for 9 years. I paid my mortgage and I paid my maintenance fee every month, $500 it started at and kept going up, to fund the fund that took care of the upkeep of the building. As an owner, made perfect sense. As a renter, I have no stake in my building. The landlord provides me a very nice place to live. I pay my rent to live there. Done deal. I do have several questions about the retrofitting proposal. I'd like to know what law allows owners to pass on costs that, no matter how costly it may be, are maintenance costs to renters, not owners. If this does go through, what methods of assistance would be available to renters who cannot afford it? I live in the same apartment complexes as Matthew. We do have a lot of seniors. I myself could not afford an increase depending on how big it was and how far out it was spread. And if we are covered to, or if we are forced to cover part of this cost, I'd like to know, does that mean then we get an ownership in our building? It only seems fair. West Hollywood has always bucked the trend of her residents. Please don't turn your backs on us now. Thank you.
Thank you. Misha Irwin, followed by Maria Sanchez.
Good evening, Commissioners, Mr. Chair. My name is Misha Irwin. I'm a 10-year resident of West Hollywood. I am very grateful for rent control. One of the reasons that I feel rent control is extremely important is because it solidifies community. Without rent control, a vast majority of West Hollywood, I feel, would no longer be able to afford to live in the city, which would fundamentally change the character and social way of our city that we love. I'm a homeowner, and I'm also a renter, and I can tell you that it is extremely valued to me that in a homeowner situation that I have a mortgage that's 30 years long. I know exactly how much I'm going to pay. But I also know that I'm responsible at the end of the day to replace a broken furnace or a pipe or whatever. As a renter, I know that I'm not responsible for those things that are not my responsibility. And I believe that earthquake retrofitting, although absolutely necessary, is not my responsibility. It shouldn't be the responsibility of any renter in this city. I can see both sides of the argument, but I'm not as worried about the person who owns the building at the end of the day as I am about me. Rent, when you talk about not having rent control, the idea of that puts a fear into my heart. It puts it into the pit of my stomach. Because it's fear that you'll lose your home. And for some people, that might be nothing. They might just say that it's fine. You can't afford your rent any longer, you'll move. I just don't think that that's fair to everybody. So in the interest of our community, I feel that we should not make a decision that allows pass-through of these fees to tenants, and that ultimately the landlords trust they will be fine. Thank you.
Thank you. Maria Sanchez, followed by Claudine Stevens.
My name is Maria Sanchez, and I actually kind of giving a sense of what it is to be new into rent control. I've been in other states, but this is the first time for a year that I've been in a rent control apartment. I've lived in the community for 6 years, and I work in the community and service the community. I also been a homeowner, and so as such, I knew as a homeowner, and other people have spoken about this, that I had certain responsibilities, and I was responsible for the maintenance or anything affiliated that with the rules or regulations that had to change my home or modify my home. However, when I sold my property and I left my property, I was able to inherit equity and walked away with income and money from that property. If I leave my rent control apartment, say next year, I wouldn't be able to do the same. So it's not fair or just for me to have to pay even further. I pay close to market rent because I haven't been there for a very long time. The previous apartments I had in this community, they were not rent control. So I am familiar with that. And I don't feel that is fair or just whether you've been here for a year or 10 years to do that, because I think it's part of the owner's responsibility, obviously, to maintain the place. I think a lot of owners probably have had well-maintained
buildings, but others probably not the same. And I think it's been mentioned the fact that this is an opportunity for them to do so. But I think as a renter, I should not be treated just like or had the same responsibility. And if we are to be asked to do more of that, then maybe one option for the city to consider is to open up co-op options, like a gentleman said that they have in New York, where there's a partnership between, the community and the owners. But I think we should be treated as renters, and as renters, we shouldn't be paying for modifications to the buildings that we live in. Thank you.
Thank you. Looks like our last speaker on this item is Claudine Stevens.
Yes, good evening. I'm Claudine Stevens. Thank you very much. I've been a renter in West Hollywood for over 30 years. I love living in this city. And I'm on a fixed income. And I'd really like, eventually, to have some questions answered. We're talking about retrofitting. I don't even know the extent. What does this entail, retrofitting for earthquakes? And when the retrofitting is completed, how is it going to protect the residents of West Hollywood? I think that should be discussed. We're just talking about retrofitting and not saying what's going to happen. And also, like as Ben said, as Maria just said, we don't have equity in our buildings. And I don't understand how a commission can even begin to think that the residents, the tenants who pay rent, should have to pay for improvements to the buildings that they do not own. Probably after retrofitting, the value of the buildings will go up. We have no equity in that. And possibly the owners of the complexes, apartment complexes like I live in, will get tax benefits. I won't get a tax benefit. But then you're saying possibly I have to pay, but I won't get any benefit. And I'd like to know where, in the rent stabilization ordinance, it says that we can be called upon to pay for part of an improvement. Today, I did call City Hall. I spoke to the clerk's office, and I spoke to the rent stabilization office. Nobody could answer that question. They said, oh, you're coming tonight. Perhaps it will be answered then. So anyway, I thank you very much for considering my questions.
Thank you. And it appears to be the last public speaker on this comment. Now we'll move to commissioner comments. Before we begin, can we answer some of the easier questions that were listed tonight? Some of them kind of have open-ended answers. We don't know the answer yet, but.
Sure, I think I can answer this last one. So the city council would have to draft an ordinance specifically about this issue, because there isn't one just now.
Well, I think that that sounds, I'm confused by that. So what is the NOI process?
So when I say, so I'm talking, if there's a decision to do an automatic pass-through,
Yes.
that would be an ordinance. Currently, there is a process called the rent adjustment process that landlords are already can avail themselves of. If they claim that they're not getting a fair return, then they can come to the city and they present evidence of their costs versus their income. It's a very set formula. It's a very kind of easy formula once you plug all those numbers in, and if they satisfy the formula, then they will get a rent increase. If they don't, they won't. So it's just that simple. But it's not an automatic pass-through based on kind of a one-size-fits-all policy regardless of costs or income. It's specific to that property and the specific costs that that property owner is incurring. So it's on a case-by-case basis based on the costs of that particular property.
If people get an opportunity, I would suggest watching our last commission meeting. Staff did a really good job about presenting that up here on on the screen and explaining that process even in more detail and kind of even throw out some comparisons of what, just hypotheticals of what might happen based upon different buildings.
I would just tend to disagree with the characterization that it was cumbersome. Because actually, legal services is the one that really does that, those hearings and that process. So.
Just one of the other basic questions, and what methods are there to assist those who can't afford it? This is just a proposal that we're talking about. Those are unanswered questions. We don't have answers to that yet because there's nothing on the table that we've approved yet.
There's nothing on the table, and we don't know what the actual costs are. We don't know, I mean, we're going to find out soon what the properties are that are actually affected, but we don't have that information. So you're kind of trying to look at this in a vacuum, which so this might all be premature at this point, but yeah, that's right.
I'm just trying to throw out some of the questions just to kind of give you an idea of what. So, no, I don't think any of the proposals suggest that you get any ownership in the property, but again, that was one of the questions. Retrofitting, what does it entail? Again, if you watch some of our presentations in the past 2 meetings, there's been some presentations on it, but do you want to maybe call someone and ask? No, I'm just kidding. You look like you wanted to say something.
So even though I'm not building and safety, it's mostly their call, but what it is, it's a reinforcement of the foundation of a building. And that could be from, and these are like technical terms, crippling walls and things that they have to do to reinforce the foundation. So in case there's an earthquake, the building is able to withstand whatever earthquake there is. Some of it will entail some more cement and so on and so forth. So depending on what the current foundation needs for these buildings, then that would determine what kind of retrofitting they'll need.
And it kind of depends on each building.
That's correct.
Yeah, and its condition. All right. So hopefully that was helpful a little bit to give you some basic information where we're at now. But if we have any comments from the commission?
Well, some of the questions, they're actually really good questions and real ones when it comes to the real world, how the ordinary people will, face this type of increases. So that is also our concern, and definitely we will be addressing these questions at the next meetings. And I would encourage public to attend those meetings so you can speak up. And whether it's here or the city council meeting, so we need to hear your voice, we need to hear your questions, and definitely I will be readdressing these questions to our staff to make sure that these questions are addressed properly, and so we have answers about these questions because those questions are relevant. Thank you for attending.
Yes, and also just to address those questions, and council can probably point you to the exact code sections. Currently in the rent stabilization ordinance, there is a section where landlords can approve for capital improvements, and as the council was explaining, if if they're not getting the return on investment that they want from their apartment buildings, yes, they can currently under the code apply for a pass-through, an upward rent adjustment, and adjust their rents under the rent stabilization ordinance. So just in big picture, because everybody's very concerned about this in West Hollywood, and you are the voices of the community that the city needs to hear from, just to frame the big picture for you, there also is code section in the rent stabilization ordinance for selling and evicting tenants and paying out those tenants a fee that's set in the ordinance if perhaps a landlord doesn't want to comply with the seismic retrofitting because it's too expensive. So the city's overall goal here is to maintain the rent stabilized housing that we have in the city and not lose it to an earthquake, but also not lose it to landlords selling that property and evicting people and changing it into condos or changing it into new apartment buildings after the old ones are demolished that are no longer rent stabilized. So those are the competing factors before the city council, and really that has the real power to establish this. And, you know, as there were no landlords present, I just wanted to let you know that that is also in the code. And we don't want, obviously, we see all the development going on in West Hollywood. We don't want them demolishing rent stabilized buildings and selling them and evicting people either. So those are, you know, some of the competing concerns on both sides of the table here. And I just want to thank Matthew, Jennifer, Ben, Misha, Maria, and Claudine for coming to speak to us tonight. Your voices were heard.
Additional comments?
I guess I looked at, I know we were supposed to give feedback on the timeline. I've looked at it. I was pleased to see there was 2 community meetings scheduled and multiple mailings. I heard tonight somebody suggested that these direct mailings aren't enough. I'm not sure there are other ways to get the word out, but obviously I encourage staff to think creatively about how to get the meeting notices out. But yeah, looking at the timeline, it looks like the community will be engaged, and I hope lots of people come out to these community meetings. It sounds like there's going to be a lot of strong feelings in the community about the proposal, and it would be great for everyone to come out and have their voices heard. So I think the timeline looks fine.
Yeah, I would like to thank all of you for coming out and discussing this issue as it moves forward. Obviously, there are some competing interests here. One of them is simply the fact that we know that we are going to have a large earthquake at some point. We have no idea when, and so I think it's good that the commission and the council are moving forward in the next few months to get this figured out, and I would just encourage you to continue showing up, to continue having your voices heard. I would say that one of the things for me that would be really useful to know is what, you know, these sorts of rent increases would really mean to you, like, you know, in your life, to be able to understand the sort of decision calculus that needs to go into all of this. And acknowledging at the same time that, you know, we just don't know yet. The data isn't there to be able to tell people conclusively what is going to happen. And so there are a lot of competing factors here. Just try to stay aware and try to stay involved. We really appreciate your feedback and the time that you spend letting us know what works and what doesn't work for you.
How did the dates work in your calendars? I know that on May 24th, I will not be able to be here. It doesn't look like, well, it actually is one of our final meetings right before, according to the schedule, but
I'll add to that, I will not be here on May 24th as well.
I think, is that right before Memorial Day weekend?
Yes, the Thursday right before Memorial Day.
Well, you can vote to post, because there's no appeal on that day, so if you wanted to postpone that to the first meeting in June.
I mean, we have 2 commissioners not here today. If we know that we're not going to have 2 for the 24th, and we have to cancel that meeting for lack of quorum. If we don't have quorum, then we won't have quorum.
Yeah, I won't be able to. I won't be able to attend this meeting because I have an event on May 20th, and I probably will take a week off after that.
Okay, so it sounds like we won't have quorum that night, so we will cancel that meeting for lack of quorum.
And so May 24th is canceled for lack of quorum. Okay, and then we'll rejigger that schedule to account for that.
Thank you. I, too, want to thank everybody for showing up tonight. I think this is actually, in my memory, this is the most people that have come to speak on one subject. Probably the only one even comparable was when we were Airbnb, talking about Airbnb, and I think that you beat them by 2 people or so. So thank you for coming out. We, as my fellow commissioners said, you've been heard, but keep talking to us. You've kind of heard the comments tonight. I really urge you to not only watch our last council meeting that's available, or our last commission meeting that's available online that has a lot of the informational presentations that will, so you can see exactly what we've seen and have a better understanding of what the alternatives are, or maybe it'll cause folks in the community to think of other options, because everything is open right now. I'd also recommend watching the last council meeting, at least the portion that's about an hour or so into it. It's the second to last item, I believe, on their agenda, where you could see each of the 5 council members wrestling with this issue and have an idea. Each of them said very different thing. I mean, they talked about the subject, but each of them in their own unique way also had different ideas of what they might want to see in this. So I'd encourage you to watch that, because that again might also instill ideas that we haven't thought of that you can bring back to either the community meetings or here at the commission, because I think the commission is made up of 5 renters and one landlord, I believe. But either way, whether it's 2 landlords and 4 or 5 renters, we all understand what the issues are here. And some of us are in rent-stabilized units. So we do understand what you're talking about, and we really appreciate the fact that you came out tonight. I would just, in terms of the comments for tonight, I think this is good. I think that what we heard from one or a couple of the members of the community is that something we always hear is and I think the city's even tried changing some of their planning notices because of it, the feedback we've received. But if we could, somehow make interesting flyers, maybe we pay a little bit more and actually put them in a real envelope so people actually treat them like real mail or something. I don't know, whatever it is, or bright red paper, something to just kind of catch people's eyes. The city does a lot of great things. Their social services department does a lot of great things, doing pop-ups of, when it's time to sign up for healthcare, they do pop-ups, or they do the bicycle training groups. I mean, if we can do just pop-ups like that around the city, keep that in mind, just so we can let people know, because everyone has a stake in this, whether you live in a rent control department or not. I mean, this is our community, and we all have a stake in it.
Commissioner Kirby, just to reiterate, those 2 meetings that you're talking about, the March 8th, 2018 meeting for the RSC was the one that talked about the process of retrofitting and how that calculates as far as the cost sharing, and also the April 2nd, 2018 City Council meeting that talks about what the council recommended.
Thank you. Yeah, so when you look online, it's the March 8th commission meeting and the April 2nd council meeting that will be, I think, very beneficial to everyone. And those are the comments I have for now. I just wanted to thank staff again for bringing this back to us and coming up with a plan. And it looks like there are several opportunities here, and hopefully we can maximize the best use and get the most feedback from those. And also online surveys and online surveys, if we could possibly, because it doesn't really matter where the ideas are coming from. We just want ideas to resolve this. Are there any other additional comments on this item? All right, seeing none, then we will move on to an update. Do we have an update on our ad hoc subcommittee? I think there's one member here.
We'll probably report at the next meeting. So we met in March. The most recent meeting was, we met, I think, on March 8th, and to further discuss, and we came up with some really good recommendations, what we believe, and that we're going to present it to the commission once the other members are present. So it would be probably the next meeting.
And for the general audience, this is an ad hoc subcommittee update. On January 11th, 2018, the Commission took action to form an ad hoc subcommittee to review the possibility of making a recommendation to the City Council regarding a proactive code enforcement program. This time is set aside for the subcommittee to provide updates to the Commission, and that was our update. We've got 2 of our other committee members absent this evening. Do we have any questions about the ad hoc subcommittee? All right, we'll move on to public comments. And it looks like we have two. We'll start with Rick Watts, followed by Jason Katz.
Good evening, Commissioners. And by the way, before I go into what I actually came here for, I want to compliment Commissioner Charity. I think you probably gave the most complete and most understandable reason why the pass-through proposals are currently being considered. And I say that as a renter who recognizes that we need to preserve our housing rather than simply let it fall down or let landlords be put into a position where they're left with no option but to Ellis out. That said, now, the reason that I'm here, I want to get some guidance, whether from you or from attorneys here, on where we need to go to submit a petition requesting a cease and desist ordinance against a tenant in our building. And this is one of the rare instances where our landlord and virtually every other tenant in our building is on the same page. We've got a problem tenant who is in the process of eviction, but as you know, it is an excruciating, particularly when it's a bad tenant, it's an excruciatingly long process. And given the nature of the problems that have been going on, we very, very much think that we need to also get a cease and desist against this particular tenant, preparatory to that, to just kind of underline the seriousness of the situation. So we've been, our landlord, the landlord's attorney, and we, the tenants, have been bounced around at various places, from City Hall, from the city staff attorney to the city attorney to rent stabilization. Anyway, I just need some guidance on where this needs to go to invoke a particular section of California Code, California 373A, which is the pertinent important point here, because we're still waiting on a ruling also from the judge on the count under the nuisance complaint for eviction. We've got one under there is a default judgment for non-payment of rent, but even there we have been told, depending on who we listen to, that it can take 30, 60 days to finally get rid of these characters. And in the meantime, we have continually people hopping fences, gates being blocked open, locks being vandalized, and people coming and going at all hours of the day or night, so that you kind of get an idea on what's probably going on, as well as there have been some threats against tenants. So we need a little help and some guidance on where we need to go to get this going. I was last told by William Litvak at the attorney's office that we needed to be referred by somebody, an attorney with the Rent Stabilization Department. So thank you.
Yeah, I would suggest talking to Ms. Regan, or to get some direction. I mean,
I can't give legal advice. I'm
No,
not a private attorney.
but she can tell you whether City Hall she speaks to, or that you can't speak to City Hall. I don't think you're looking for legal advice.
He's asking for an attorney under state law. He was citing state law. I'm sorry.
Okay.
I can't do that.
We'll move to, or the next person is Jason Katz.
Good evening, Commissioners. Jason Katz. It may be too late to say what I want to say because it seems like the council, as the commissioners already voted, so I'm not sure if I should be saying what I'm saying, or if it even, but I hope it does and it doesn't fall on deaf ears. The question was brought up as to, I think it was started by Commissioner Topchin, about what the difference is if it's a legal or illegal spot. I think part of the consideration, maybe what the examiner was pointing out, is that it's an illegal spot, is that the quality of the spot is less than a legal spot. Everybody knows that a legal parking spot is 7.5 feet or 8 feet or whatever the width is by code, as opposed to something which is squeezed in and put there by, okay, let's fit you in to try to get you a parking spot, which is probably what happened. I wasn't around 20 years ago, so I can't tell you what happened or whenever it did happen. But obviously that was, you know, the quality of the spot is diminished when it's an illegal spot, because if there's enough room and everybody can park there and you don't have to worry about anybody coming by and scraping your car when they're carrying something heavy in because it's a lane that people pass through, well then it's a much better spot for you as opposed to when it's illegal and it doesn't have the clearance which it should have. I think that's what the examiner was probably referring to when saying illegal and legal and illegal. That could be one of the things. So when it's the question is in the code where that is mentioned, I think it's not only health and safety, but I think it's also the quality of the service that was being provided. I think goes down once it becomes illegal. I think that was one thing. And then I mean, just something else in the staff report, they mentioned the fact that it's not necessarily the rent reduction is not something which is to pay back the tenant or pay for the damages or to punish the landlord or whatever it may be. It's to prevent as they call it, the words of the staff report, a backdoor rent increase, which we all, I think, agree in this case that it wasn't, being that it was an illegal spot which was cited by the city. It wasn't taken away by the landlord. It wasn't something that they said, oh, we're not painting your place for 3 years, 5 years. It was taken away against everybody's wishes. I mean, the decrease in rent is for the landlord, and it would have been easier for them to just say, hey, keep the spot and pay the extra rent. So when we talk about illegal or illegal, and I think that's what the examiner possibly was referring to, therefore, that it's not, even if we were to say that it shouldn't make a difference about the quality of the spot, but this is not something that the landlord chose to do, and it's not a reduction, well, it is a reduction, but it's not a reduction in services to the highest degree, and I think that's what they were referring to. It wasn't a backdoor rent increase. So I think those are the 2 points which I would have liked to have made during the, I don't know if it's possible to reopen the deliberation, but that's, thank you.
Thank you, Mr. Katz. We will now move to, is it staff report or staff comments or commission comments? Commission comments, final comments.
Yeah, I want to make an announcement. This is partially on my behalf and on behalf of the Russian Advisory Board of West Hollywood. The Russian Advisory Board will be hosting the 17th Annual Russian Culture and Arts Festival in West Hollywood Plummer Park on May 20th, Sunday, between the hours 11 a.m. and 7 p.m. And that event has become a trademark event for the city of West Hollywood, and everybody is invited. There will be a lot of activities for children. There will be big gala concert, the big children's concert. Typically, there are thousands of people expected to go on that day. In Plummer Park, it's a unique event in West Hollywood, so everybody is invited to attend. It's free of charge. Parking is free. Just come and have fun.
Will Commissioner Topchin be performing this year?
You are revealing all my secrets. Yes.
For those in the community who have never been to the Russian Gala concert, it is such a treat. It's really impressive. They get really, really talented people to come perform, and Commissioner Topchin is usually one of the featured acts, and it's a really, really good show. So I wish everyone should come out and check out the gala concert.
Thank you, which is going to be held at 5 p.m., the start time. For the gala concert, the children's concert starts at 12 p.m.
And this is April, what day?
It's May 20th, yes,
May 20th.
Sunday. Yeah.
I wanted to take an opportunity to let everyone know that this is my last meeting. I am resigning from the commission because I bought a house in Los Angeles. Obviously, I will not be a resident of West Hollywood any longer, so I cannot serve on the commission. But it has truly been my great honor to serve the city of West Hollywood, to serve our amazing community that comes out, that lets us know what's going on, that participates in the democratic process, and to be a part of a city that is so progressive and tries, so many new things to serve its citizens. This commission in particular is formed around the idea that housing is a human right, and it has been, again, my great honor to participate in that and protect human rights in that manner. Just thanks to my fellow commissioners. It's really been a pleasure getting to know all of you and serving with all of you. Thank you so much to staff, to Councilwoman Horvath for appointing me, and again to the citizens of West Hollywood. I will miss all of you. Thank you.
Well, congratulations on your house, first of all, and it's what a disappointment that you're leaving. I've really enjoyed serving with you, and you have been an amazing member and kept me in check at times, and I appreciate that, and made me think about certain things in a way that I wouldn't have thought about had you not said or mentioned them. I just have one much less important announcement now. The Children's Fair, WeHo Kids Fair, is this Saturday at Plummer Park. It's a 23rd annual Kids Fair. They have lots of activities for kids of all ages. It'll be at Plummer Park 10 to 2 on this Saturday. Any other comments?
I'll just congratulate you too on home ownership, and thank you so much for your service to our community. Your presence on the commission will be felt. Your lack of presence will be felt.
And we'll move to staff report, or staff comments.
Commissioner Buckles, thank you for your service. And I also wanted to just give you guys a friendly reminder of our next meeting, which is April 26th. There is a closed session item scheduled for 6:30 p.m., so it's very important that you guys get there at that time. That's it. Thanks.
Thank you.
Please send us a reminder to when the time comes.
All right, so do we have a motion to adjourn?
So moved.
All right, we're adjourning the meeting till April 26th will be our next meeting.